Yeah, today is 23rd of May 2022, and up to today no any legal improvements in appointing of sons custody from criminal colonization. Also, I found a document in English language, might be a remote translation, might be someone placed it in my memory stick remotely. I do appreciate feedback of any blue managements, even if such are judges from UK or any legal managements of European Union institutions. Difficulty of that document is at the court level. I do understand it, but the problem in whole globe is absence of legal effectiveness of power of law. Whatever contents of petitions or concerns are. If power of law as a factual instrument doesn't work in the courts, then that legislation is having no sense. Judges, which are mostly criminal females, do not realize that, since aren't accepting own responsibilities or legal time frames for understanding of possible negative consequences in case they neglect or violate power of law. When legal structural order is depending on the power of legality, national legality, and such is broke down by the authorities, whatever motivations are, they do not realize inevitability of consequences. Several of the legal managements are having honors on the globe, but competitive bodies and criminals, they do not realize possible consequences for their competitional crimes or even inactivities, discriminations, things like that. If I look to the performances of the courts, they are not in the legal frame. They are not in the even trusted field. Trusted field is coming when people and court representatives, employees, personnel are capable to accept power of law in official issues or obligative solutions above personal or authoritative will. That's the point where the structure was destroyed by the crimes, because leveled managements and authorities aren't realizing seriousness of power of law in compared to own activities or professional issues until they are justified. Animals' perceptions, and most of such are at the court level. I personally do not respect any women who are acting against the law or who are performing crimes for any types of benefits, pleasures, or any parasitic interests. But problem in the courts is that obligations and responsibilities aren't taken into account in order of their own power keeping in the systematic performances. Legal effectiveness is a heavy machine, is a scrambling machine which having no any separations in the levels, in the nationalities, in ages, in males, in capabilities. but when facts of any types of crimes or indirect involvements into appointed issues are existing, to set back legal effectiveness is required only enforcement of the legal consequences. I'll try to explain to British perceptions that distractions of legal structural developments when exist civil obligations or judgments or agreements or electronic managements is the same as to lose the virginity. Losing of virginity by the appointed crimes is giving the natural result as in woman's body. But the problem is to set back that virginity for structural developments, and for that is necessary only forced locks of the ones involved, applying of systematic consequences, and setting the judges to be responsible for their decisions and activities. Criminal judges are also meat. It's criminal meat if they do not understand the way of their obligative reactions to any types of legal issues or decisions and functionalities. Their systems can be blocked in any spot on the globe. But problem is to make the courts functional, nor competitive or authoritative. Authoritative performances are too dangerous if thus are leaded in black perceptions, such as visional or sneaking in into the private legal interests without any procedural order. Consequences in such issues and such matters might be inevitable if exists an aim for obligative solution. Obligative solution which might be based by the laws and facts is depending on the legal effectiveness, and that's the reason why European Union court case is having international scale for situational and obligative solution in Republic of Latvia.